and we'll go ahead and get started. So thanks everybody for joining us today. I'm Michael Thompson, partner and senior wealth advisor here at Copperleaf Financial here in Williston. We have offices in Williston and also in Rutland. My guest today for our monthly town hall is Andrew Kasner, and Andy. Andy is a partner at Langrock Sperry & Wool. He's been there since 2015. I'm a graduate of Villanova Law School, and Andy also has a master in taxation from Boston University School of Law, which is, I find, really helpful. That additional background in tax is important background, I think, especially for this area, for estate planning. Today, we're going to be talking about what taxpayers in Vermont should be thinking about in terms of their basic estate plan, and when maybe should you be thinking about updating and taking a second look at your estate plan. So we're gonna kick it off with, what are the basics, Andy? So in your experience working in this area, and you focus exclusively on estate planning, if I believe that's correct.
That is correct. That is correct.
What are the basics? What should every Vermont resident have in place for their basic estate plan?
Well, first of all, good afternoon. Glad to be with all of you. The basics of an estate plan, there are some tangential documents, but the real core of an estate plan that we would typically prepare would involve a revocable trust, what we call a pour-over will, and a durable financial power of attorney. A fourth critical document that straddles the line between being a healthcare document and a legal document is an advance directive. Not that it is any less important than all the other documents, but thankfully the practice in Vermont is to use a standard form for that. Now, this is a document that a doctor is going to be looking at, perhaps in a hurry. It's great that everybody uses the same thing. So you might get that at your doctor's office. You might get that from your estate planner, but it's sort of the fourth piece of the puzzle that everyone should have. Similar to the advance directive, in that that's a document that applies while you're living, but when somebody needs to be making a decision for you because you're unable to do that. The advance directive is a healthcare related document. There's also something called the durable financial power of attorney. That is the document in which you would appoint an agent to make financial decisions while you're potentially incapacitated and unable to make them. That's always a big area of confusion when people are new to the process. And sometimes you'll find people who are serving as an agent under a power of attorney for a loved one, and then they pass away and the power is gone. So the advance directive and the power of attorney are documents that apply while you're living. And then the trust or will, hopefully trust, is what will control the ultimate disposition of your estate.
And those two, I'm glad you made that distinction. So you talked about two important documents that come into play during our lifetimes that help facilitate our overall estate plan, which is really how to take care of things, is kind of how I think about it, when we can no longer take care of them ourselves, either during our lifetime or after we pass away. And the other two documents you talk about really kick in at death. What happens then? And there are also other roles to play that individuals or institutions and sometimes can play on our behalf after our passing that are in those other two documents. Is that right? How's that work?
Correct. So first, I'll just briefly speak about the distinction between a will and a trust. Most people are familiar with wills. Most people are familiar with the term executor. As Michael said, you're appointing somebody who's going to manage your affairs after death. That can be an individual, a loved one, a family member, or it can be, what we would call a corporate trustee or executor, someone other than an individual. With a trust, there's sometimes confusion because people have preconceived notions about trusts, who they're important for, and why you might have one. I will often call a trust a private will in my initial discussion with a client, because that's the message that I'm trying to send about what we're accomplishing with the revocable trust. There are revocable and irrevocable trusts. The names are very similar. It's very easy to get them confused, and they accomplish very different things. So sometimes I'll use that private will nomenclature private will nomenclature just to kind of get the ball rolling on understanding what we're accomplishing. And what the revocable trust allows, and the reason that I sometimes call it that, is it allows for the private administration of your estate. You don't need to go through probate, and the court doesn't need to sign off on every step in the administration process.
Yeah. And can you describe briefly the different roles that are involved in different kinds of trust, maybe a revocable, that mechanism that you just talked about, or an irrevocable trust, and maybe a little bit about when those two different types of trusts in general might be useful for a family?
Sure. So when you have a revocable trust, you are your own trustee during your lifetime in almost every case. The idea is that it is an extension of you. It doesn't have a particular unique tax ID. You don't have to file a tax return. There are all these attributes of the revocable trust that are highly flexible. And as the name would indicate, you can revoke it anytime you want. You can move assets in and out. Those aren't taxable or otherwise significant events. From a financial perspective, it is, of course, significant that you fund your trust as best you can during your lifetime. And when you do that, you're just transferring assets from yourself as an individual to yourself as trustee of your trust. At such time as you pass away, your revocable trust will, for the next period of time, become irrevocable. The person that you name as your trustee is going to serve nearly an identical role as an executor. They are going to be the person that administers your estate and takes care of those, nuts and bolts to make sure that your directions are followed. It is also possible, and this is what I've noticed to be kind of a common area of confusion, is what happens if you want an asset or assets for a particular beneficiary to be held in a continuing trust. And what most revocable, well, I shouldn't say most, many revocable trusts provide is that upon the death of the grantor of the trust, there would be a continuing trust for a beneficiary or beneficiaries, and the directions for those trusts are contained in the revocable trust itself. So getting back to the roles, the person who you name as trustee would initially serve that executor type role, but again, doing so on a private basis. They could also continue on as trustee of a continuing, now irrevocable trust for a beneficiary that may be too young to receive assets, or even if over the age of majority. It's very common for the creator of a trust, the grantor, to want their estate to be held for a particular period of time. It's usually age based. Now, what the right age is really up to the individual. It could be 21, it could be 30, it could be 40, it could be forever. Usually forever is only if there is some special need or there's a good tax reason to do that.
So to simplify, or just to interpret what you're saying, if I might have a revocable trust that I put in place, at my passing, there's a named trustee whose responsibility is to operate or follow the instructions of the trust. And if I have young kids, I might want to have a trust that continues past, beyond my death for a period of time, until my kids are old enough to manage money on their own, at which point, there are instructions to pass that money along to the kids, something like that. Is that basically what you're saying?
Absolutely. And you mentioned young children. That's a really important reason to not only have a trust, but have directions for that trust to continue. A minor is not capable of taking assets themselves. If there are directions for an asset to go outright to a minor, the probate court needs to be involved, and the parent needs to be formally, even if they are obviously the guardian, they need to be confirmed in that capacity by the probate court. But if you have directions for a continuing trust, you can avoid all of that. And then beyond the age of majority, there may be good reason to have the trust continue.
Yep. We've got a question coming in. By the way, a little bit of housekeeping. I want to just let all our attendees know that please feel free to ask questions. Go to the Q&A at the bottom of your page and go ahead and enter questions if you have them. Feel free to do that, and we'll get them answered. We've got a question now before we kind of follow up on that last section, Andy. And in Vermont, I've seen sometimes as different attorneys will create one family revocable trust, and sometimes there'll be two individual revocable trusts for the two partners. What's the thinking there, and what's really the purpose of those revocable trusts here in Vermont these days? And how do you think about kind of the one combined joint revocable trust versus individual ones?
Sure. Well, that's a great question. It's a big part of what we do as estate planners. A joint or family trust is always a nice fit when it fits the client's circumstances. It's easier, but it doesn't always fit in many cases, actually, because there are tax-driven reasons why you might, in a couple, have separate trusts.
Mm-hmm.
And that almost entirely involves the Vermont estate tax, how it functions, and how you can ensure that you are making the best use of your credit as an individual Vermonter. The water gets a little bit deep in terms of the why, but certainly a valuable topic to talk through, and I'm glad to take a crack at it.
So you mentioned taxes, and you mentioned Vermont, which really raises the question of lots of times we see people going through the estate planning process with the primary purpose of minimizing or avoiding estate taxes. There are lots of other reasons, good reasons, frankly, for, as we've talked about, for having an estate plan in place to assure the smooth and proper transfer of your stuff, of your assets. But let's talk about the tax issues. And correct me if I'm wrong, but I think there are really two or three different pieces of tax to think about. One is the federal estate tax, and there are gift taxes and other things associated there, which you might refer to. And then there's Vermont. Vermont has its own rules, right? Can you talk about that a little bit? And what are these amounts? And oh, by the way, do we see any changes on the horizon that we should be aware of?
Sure. Well, as Michael said, there really are three tax circumstances that you want to be particularly in tune to in estate planning. Income tax is actually really important. Maybe I'll set that aside for the time being. But there is both a federal and a Vermont state estate tax. It is, a common misconception is when somebody receives a bequest, when they receive an inheritance, do they pay tax? The answer is no. There is no tax on the individual beneficiary level. However, there is tax that may be due from the estate. The federal tax is extremely penal. It's a 40% tax. However, those rates, or I should say not the rate, but the tax-free amount that you can pass has gone up quite a bit and was actually doubled in 2017. So right now, each individual can pass $12 million free of federal estate tax. They call that the unified credit. So you can make gifts during your lifetime or pass assets upon death. If you make gifts during your lifetime, the credit is essentially a declining balance. If you give away $1 million and you had 12, you have 11 left. Now, perhaps for further on in our discussion, there are some wrinkles for that's going to change again. The increase was temporary. It's not because of intervening legislation that could happen, but the way the law was written in 2017, it's going to expire after 2025. So perhaps more on that later, but the federal estate tax it's penal, it's 40%. You want to avoid it at all costs. And there's also a federal gift tax. One of the nice things about the federal tax is there's a concept called portability. And a lot of what we do is planning for husbands and wives, and of course, ultimately for the children. With portability, the federal tax-free amount can be left to the surviving spouse. So it creates some efficiency when one spouse passes away, because the surviving spouse may be loaded up with all of the family's assets, but they can also be loaded up with all of the available tax-free credit. Vermont doesn't work that way. Surprise, surprise. So that is where a lot of our planning comes into play. That is why we need two trusts. You may have heard the term credit shelter trust. It's exactly as it sounds. You can't simply leave all your assets outright to your surviving spouse and make good use of your own estate tax credit. The way that the law works, and it's a little bit good, but also a little bit bad. There's something called the marital deduction. You can leave all of your assets to your surviving spouse. You're entitled to a deduction on a Vermont estate tax return. The same is true on the federal level as well. Anybody can leave an unlimited amount of property to their spouse. It's not tax-free though, it's simply tax deferred. So there's no tax when it gets left to the first spouse, but before it gets to the children, then 100% of the tax is going to be paid by that surviving spouse. And in Vermont, the first to die spouse's Vermont tax-free amount, which is a $5 million tax-free amount, will have gone out the window at that point if there's not some intervening planning. And we do that with the two trust structure.
So I think what I'm hearing is, in answer to the question, is it okay to have one joint revocable trust versus two? It may depend on the size of your estate. If your
Absolutely.
estate is expected to be under 5 million, then maybe I'm wrong, but help me out here. Expected to be under 5 million, then maybe the joint trust will suffice. But over that amount, probably prudent to have two. Am I getting that right?
That's exactly right. That's exactly right. Because every dollar over $5 million is going to be subject to Vermont estate tax potentially, which is a shame because there's an easy fix. And the two trust structure provides that fix. Now, the only wrinkle that I might introduce is Vermont does not have a gift tax. So sometimes I will have clients who say, yes, our estate's going to be over $5 million. I really don't want to do the two trust structure for, a variety of reasons, whatever they might be. And sometimes I will say, okay, if you're really not interested in the two trust structure, what are your future plans? Do you plan to spend down the assets? Do you plan to engage in any significant gifting so that it is less likely that your estate exceeds $5 million upon your death?
Mm-hmm.
But ideally, what we'd like to see clients do, and most will do, is have a two trust structure in place. I can talk a little bit about how those function if it's helpful.
Yeah, I think so. But I also want to remind people, this is a concept that maybe you'll agree with, Andy. that I try to remind our clients when we talk about estate planning is there are really only three places that our stuff can go.
Yep.
Our assets, our home, all the things that we own can either go to family, or it can go to the government, federal government and the state, or it can go to charity. And that's really a charity, or, well, I would say family or other individuals, taxes or charity. And to a certain degree, we get to choose, how we want to kind of structure where it goes. And the other thing that I like to remind people of, even though the Vermont tax rate isn't as punitive as the federal estate tax rate, you talked about the 40% punitive level of taxing estates at the federal level. Vermont's is 16%. Am I right? 16% above 5 million. So if I have an estate that's 6 million in Vermont, and then my estate's gonna owe $160,000 within a short period of time to the state of Vermont, and I've got to come up with the cash to do that. And if most of my estate is in property and in my home or a couple of pieces of property, it might be a problem to have to sell things to generate the cash to kind of pay that tax. So if we can avoid it by doing some structuring of our estate in the way that you describe ahead of time, nice to not have to pay that and have to have the family scramble to come up with the money to pay it. But
Absolutely.
Yeah, go ahead and describe that, in broad terms, that structure. And then I want to shift and talk about kind of some new issues that we face as over the last couple of decades, as the internet age has arrived, and we all have online lives. We'll talk about that in a minute, but go ahead and talk about that structure now.
Sure. So what we're essentially, in its simplest sense, trying to get clients to do is to use their credit when they pass away. There are several different ways you can actually use your credit, and it's almost easier to describe by exclusion. What you can't do is leave everything outright to your spouse, because that is a tax-free transfer, or again, tax deferred. So you can leave assets directly to the children. You can leave assets to a friend. Anybody but the spouse will generate a taxable event. Not everybody wants to give their assets away to the kids or to third parties and create a taxable event upon their death when their spouse is surviving. So there is a solution in the law, and that is to create what is called a credit shelter trust. That is a trust that allows the spouse to have continued use and access to the money if they need to. But essentially, there is enough of a string attached that the IRS does not treat the transfer to the credit shelter trust as qualifying for this marital deduction. So there's enough of a string that it creates that taxable event. And I know it sounds strange. We all want to avoid taxes. Why are we talking about creating taxable events? But in Vermont, that's what you need to do in order to use your estate tax credit. So what a common, there are two ways to do it. I happen to have a strong opinion about the way that I like to do it, but a revocable trust will provide for assets to go either outright to a spouse or into a credit shelter trust. The big issue is, how do you fund the trust?
Mm-hmm.
There are funding formulas in some trusts, and those might provide that, the maximum amount of the maximum. It'll be a paragraph of tax language, and frankly, clients don't love it because it's hard to interpret. But what the formula will say is, essentially use up my Vermont estate tax-free amount, make sure it gets used. I don't love that for two reasons. Number one, you might have a client who's, just barely over the threshold and doesn't need to use the whole $5 million in order to get the necessary advantage from the planning. All you need to do is make sure that the survivor isn't left with more than $5 million in his or her name. So what I like to use is what's called a disclaimer trust. And it is a form of trust that allows some of the action to take place after the first spouse's death. You don't need to decide when you're executing your estate plan, planning to continue to live for years or hopefully decades. You don't want to decide then what's going to happen. With the disclaimer trust, the spouse can make the decision post-mortem. So the first, and it also has the advantage of the directions in the trust are clear. If someone picks up the trust, the first thing they'll see is leave everything to my spouse. And that makes people comfortable. There will be a second direction that says, if my spouse disclaims an asset, it shall flow into a so-called credit shelter trust. So again, it's that surviving spouse making the decision. Now, there are rules involving disclaimers. The big one is you have to do it within 9 months of death. But the good news is you get that flexibility. The spouse can then decide whether a trust will be funded and in what amount. So that it's a really flexible way to allow couples to manage their potential Vermont estate tax exposure.
I'm with you, Andy. I prefer simplicity and flexibility, and that approach I love because it does provide that flexibility and simplicity without having to describe a formula that may have to be changed at some point in the future when, you know, the disclaimer or the simpler approach allows for change over time and flexibility for later on. So
and the other issue, of course, is the law is constantly changing.
Constantly.
Vermont has been fairly steady. We've had a slow scheduled increase in the tax-free amount, but the federal amount has become, you know, a political football, and it's going up and it's coming down, and it's difficult to plan with any certainty or with any formula that's likely to fit in the future.
So tell us briefly, come back to this issue about what's going to happen in a couple of years with the federal estate tax law. I know you mentioned earlier that it's due to sunset. I think that's the language that you used. What are we looking at, and how should people be thinking about that now? Are there steps that people should take now before that happens?
Absolutely. When the law was put into place in 2017, for congressional budgetary reasons, I don't pretend to understand or be able to articulate, but you know how our laws are made and how it works. But for budget reasons and deficit reduction reasons, all of the tax breaks, and frankly, some are breaks, some aren't. You know, taking away the SALT deduction, people in the Northeast haven't loved that, but the bottom line is this increase in the federal estate tax-free amount and other pieces of the law for individuals have a built-in sunset after 2025. So it's nice to be able to tell clients you've got $12 million and your spouse has $12 million, and maybe you don't need to worry about federal estate tax. One thing I like to point out, you know, I'm using the number $12 million. That's what the tax-free amount is this year. That is actually an inflation-adjusted number. So what you'll actually see in the text of the law is the tax-free amount used to be $5 million. That, of course, had been adjusted for inflation, but the base $5 million amount was doubled to $10 million. Now, with inflation adjustments, we're at 12 million. It's a nice even number for this year. When it goes down, and it will go down after 2025, it's going to go back to $5 million. Now, there's a lot out there on the internet that says it's a use it or lose it amount. That's helpful, but it's also a bit misleading. And this is one of the major areas that I'm talking to clients about. You definitely want to use it while it's there and avail yourself, you know, through transfers to trust or outright gifts. Avail yourself of the $12 million. It's not entirely a use it or lose it amount. You have to use the whole thing, or I don't want to make this too complicated. If you use most of it, but not the whole thing, that's okay too. But one thing I will say is if you use half of it, which with the inflation adjustments, whether it's 5, 10, whether it's going to go back to 6, 6.5, nobody really knows. But let's say you use half of the $12 million amount, and you expect to have your other half left when the law changes back to 6. That, in fact, is not the way that it's going to work. So I think there'll be a lot of folks who may be engaged in some planning and didn't get good advice, who are going to be very surprised when, they maybe made some significant transfers planning on having the remaining 5 or 6 left over in 2026.
So what I'm hearing is that it's probably important if for folks that either haven't done planning or it's been several years that they put their estate plan in place, probably prudent to revisit it now, well before 2025, to just understand, are there implications, are there adjustments that you should be thinking about making to your estate plan in anticipation of the sunset in 2025.
Absolutely. And, I certainly acknowledge that any planning of this kind it's going to involve a major financial decision. And it's something that academically may be obvious from a dollars and cents perspective, but it's something that I hope clients will have significant lead time to think about and consider, because I personally don't want to be in the situation telling clients that the best financial decision they can make is to give away $12 million and have them have a month to think about it. Right. And I trust there will be a rush at the end of 2025, but that'll probably happen anyway. But to the extent that folks can have some time to process and think about how these changes may impact them, I think the more time, the better. Yeah.
Thanks, Andy. There's one more thing I want to mention before we segue and shift to talking about digital assets, which I'm really excited to talk about. But this one more issue has to do with this thing called a step up in basis. When we're talking about clients giving away assets, it's really, really important that there could be unintended consequences to giving away assets to the next generation, where if I wait and pass it at my death, there may be zero tax due to the recipient at that point. Can you talk a little bit about how the step up in basis works and what I mean by that, and
Sure.
How should clients be thinking prudently about taking advantage of that?
Well, first of all, back to what we were just talking about, that is one of the many reasons why, if you are thinking of engaging in some significant gifting, you really need time to not only think about it, but engage in some financial analysis of what you might give, because right. Assets are entitled to a step up in basis upon death under our current law. Now, this is something that it's been on the chopping block, so to speak, or at least there have been threats of getting rid of it. Folks were up in arms. I think it was about 1.5 years ago. Everyone thought it was a certainty that they were going to get rid of step up in basis. It didn't happen, but it's a concept that exists in the law that essentially says if most folks are familiar. Usually the easiest example is to talk about a stock or a house. Yep. Your purchase price generally is your tax basis in an asset. That can be adjusted, but the easiest way to think about it is, in most cases, your acquisition cost, your purchase price, is your basis. When an asset increases in value, you are subject to capital gains tax on that increase in value. Except there is a wrinkle in the law that when you hold property at death, it is the basis is adjusted to the fair market value as of the date of death. So it's a really nice thing, and it's something that you don't necessarily want to lose. When you are making a gift during your lifetime, the recipient of the gift gets what we call a carryover basis. They get the same basis that you had. So, folks might be surprised if they make a gift of a low basis asset, that there is some built-in capital gain. So again, it's extremely important to consider what assets you might be gifting. The whole reason that the step up in basis exists, and this is, I think, why there has been a push to get rid of it, is because particularly on the federal level, the government recognized that if they were going to tax assets at their full fair market value when somebody passed away, and potentially cause them to pay a 40% tax, which, as you alluded to earlier, often estates will have to liquidate assets in order to pay tax. So without the step up, you might find yourself in a situation where you owe a 40% tax. It's based on the value of the asset as of date of death, but the asset really isn't worth what it's being taxed at, because upon liquidation, there might be a significant capital gains tax that's due, and the liquidation might be forced because it would be required to, in order to raise funds to pay the tax.
Yeah.
Now, it's interesting now because there are many people who are not subject to estate tax. With the $12 million tax-free amount per person, most folks are not subject to estate tax. They do still enjoy the step up in basis. So right now, under the existing law, if you're under the $12 million threshold, it's a nice place to be, because you do get that step up in basis and you're not paying estate tax. Unfortunately, folks in Washington have realized that, and I think the step up has become, an easy potential area to attack, because the original justification for it doesn't exist quite the same as it used to.
Well, and it also points out the distinction that you drew early on in our discussion today, which is there are different types of tax. We've got estate tax, but we've also got income tax.
Absolutely.
And I think about this whole step up thing. So often I hear people saying, "Oh my gosh, I've got to give away my assets so that I don't have to pay for nursing home expense, or for whatever reason, I've got to give things away." But the best example of this, I think, is, mom and dad bought a camp on the lake for $100,000 20 years ago. Today, with the inflation in real estate, it's worth $2 million. If you give that away to your daughter before, today, she gets your basis. So if she goes to sell it, she's going to pay tax on that gain, on the difference between the $100,000 and today's $2 million value. Whereas if you pass it along at death, her cost basis is going to jump up to that $2 million. And if she turns around and sells it, she's going to owe no tax, income tax on that thing. That's kind of the example I think about. So again, back to prudent planning. It's really important for the way we think about all this stuff is get the right people on your team, get the right people at the table. Obviously, as wealth planners and financial planners, we want to go through all this to make sure we're taking a comprehensive look at what you're doing and what your plan should look like, and work with Andy and work with the attorney and the CPAs to make sure everybody's kind of dotting their I's and crossing their T's, and we got a good plan in place moving forward. Let's shift and talk about digital assets, Andy.
Sure.
It used to be that life was a little easier, and we had kind of two categories of assets. We had what we call tangible assets, that are things we can touch and see and put our arms around. And we had intangible assets, which didn't have a physical presence, but maybe they were the value of a trademark or something like that. But today we have a new category of stuff. We have things called digital assets. And I saw a study the other day that said that people under age 75 have 180 different online presences or different types of accounts, whether it's a Twitter account or a Facebook account or email, or maybe an Apple iTunes account. All that stuff represents digital assets, right? Are you seeing that this has become kind of a new area of thinking in estate planning?
Absolutely. And as you say, there's no universally accepted definition of what a digital asset is. It can be very wide ranging. My goal today is hopefully to first distill it down to what do we need to do in order to deal with this stuff? Because it can be a Facebook page, an Instagram account, a Twitter account. It can be personal photos that are stored somewhere on the internet. It can be something, kind of sexy like cryptocurrency. Everybody likes to talk about cryptocurrency and what do we do with that? Some people have online businesses, a YouTube channel. The sky's kind of the limit as far as what a digital asset can be. And from my experience, at least, that caused quite a bit of indigestion in the estate planning bar. We have to deal with this thing, digital assets. What do we do? What do we do? There's some law on it now. Thankfully, Vermont has adopted a uniform law. It's called the Revised Fiduciary Access to Digital Assets Act, that came out in 2015. Vermont did adopt a version of that in 2017.
So what does that law do for beneficiaries, and for what does it do for me as an individual that owns a number of digital assets? I have a digital presence.
Sure.
And then how does it help my beneficiaries at my passing? How does the law function?
Well, the first thing I'd recommend is to not actually try to read the law, because when you pick it up and you look at it, it's, I read laws every day and it just kind of feels like gobbledygook to me. But I think the best way that I can explain it is, and most of us are familiar with this, even if we're not thinking about it day in and day out. Most digital assets are subject to terms of service. It's that box that you check when you sign up for an account. You don't read it, you don't care, you don't think about it. But what most of those say is that your asset is non-transferable upon death. They're usually very specific. Twitter goes so far as to say that we're unable to provide access to anybody who's seeking, the account of a deceased loved one, regardless of their relationship.
Yeah.
So that's very common, and there are some privacy laws that these online providers have relied upon to essentially say, we can't do it. We're out of luck. We are not going to violate this law by giving your information to somebody else. Now, what this the fiduciary access to digital assets law provides is, I call it a solution. It's really some substantive law that counteracts these adhesion contracts, these boxes that you check, these things you have to do in order to participate in this digital universe. And there are really two steps. I'm in my 40s. I'm supposed to be this, magical generation that grew up without email and grew up without computers, but we got them later in high school or in college. So I've sort of seen both sides of the equation. And I didn't understand what the heck the law was talking about at first, because it talks about an online tool.
Mm-hmm.
I have no idea what an online tool is. Is it the computer that I use to access the internet? Is it something sophisticated that only an IT person understands? All it really is acknowledging that some of these providers might have a solution that exists, on their webpage, built into their account in order to manage assets upon death. I mean, it's not really a beneficiary designation because it's not really saying who's going to get the asset, but it's, who's going to be entitled to the asset post-mortem. Google has something called an interactive account manager. Apple is coming out with this digital legacy tool. Now, again, when you hear the nomenclature online tool, it's like sort of sounds like nothing, or at least we don't know what it is. But what it is the service provider offering the customer a solution and a way to deal with their digital assets upon death. It is also the case that if you have, again, maybe easier to think about it as a designation, whether it's a beneficiary designation or a designation of a fiduciary. If you filled out this designation and have something in place, that's going to trump the terms of your estate plan. It's just like a beneficiary designation with a retirement account or a life insurance policy. If you have separately designated somebody to receive an asset, that is going to control the asset and not your estate plan. So maybe an easy way to think about the online tool is a beneficiary designation for your online assets. Now, that's sort of step one of the law.
Mm-hmm.
Step two is an acknowledgement that some companies will not offer this online tool, and that you should be able to control your digital assets with a direction. And that can be in a will, that can be in your trust, or it may be in a power of attorney, because there may be a need to access digital assets while somebody's living, but not deceased. So it's really important as an estate planner to make sure that we have directions in all of these documents. Yeah. We have a paragraph that we use. I'm sort of the mind that it's more important to have something in there. It's less about what it says, but more about that you've acknowledged it and you have some language that's authorizing your fiduciary to access the asset. And given the fact that we have this fiduciary access to digital assets law in Vermont, and that it allows for, or it anticipates that there might be a direction in any of those three estate planning documents, that generally is enough to trump these onerous terms of service that we talked about in the beginning that have proven problematic in this area for a while.
Yeah. And doesn't it really just codify and recognize that I can assign a fiduciary, I can assign somebody to be my digital fiduciary, to act on my behalf within the scope of my overall estate plan and kind of the rules that these different custodians have. It allows the custodians of my digital accounts, whether it's Facebook or Apple or whoever, to recognize I've officially given fiduciary status to somebody to act on my behalf at my death.
Exactly right. Exactly right.
Yep. By the way, I want to always recommend that everybody that has an iPhone or a Google phone, go online and find the resources there. Apple does have a legacy contact that you can assign to your iPhone and your computers, and others do as well, that kicks off that process. So I think most people aren't aware that you can actually assign that, because if I die today and I've got my iPhone and my MacBook and all my stuff, I want somebody to be able to go in and have access to my photos and turn everything off and kind of take care of things. And without that, Apple and the others have provided a tool for us to recognize those people. But without that, like the rest of, I haven't taken care of all of my estate plan. I haven't really put a plan in place to get those things taken care of. I also think, Andy, that it's important to, like everything in our estate plan or our financial lives, to really have a plan. And we recommend that people start by taking an inventory. and really start by making a list of all the different accounts and different places where you've got digital assets. And oh, by the way, you talked about some of these assets may have no value. It might just be an online presence or access to email, things like that. Some may actually have value.
Absolutely.
For example, I think about credit card points. I love using my American Express card for as much as I can, because I generate points which I can use to get upgrades on flights or buy things. And there's value there. There's actual monetary value to those things, whether it's hotel points or credit card points or Sky Miles or whatever it is. Those things have actual value that should go to someone, and that should be recognized. And other things you mentioned, if I've got a YouTube channel or an Instagram page that's generating revenue, there's actual value to those things, in addition to the Bitcoin and the cryptocurrencies that may have value too. So start with making a list. Wouldn't you agree?
Absolutely. One thing I will frequently find myself telling clients is not to devalue my own work as an estate planner, but you can have the most beautiful documents and the most complete plan. But if you don't have a list of your assets and you don't have a roadmap and these other pieces that would hopefully be in my file, your loved ones are starting from scratch. So anything practical that you can do is going to put you ahead of the curve. I've had clients do different things. Recently, I had a client who wanted to write down all of their passwords to everything, put it in a sealed envelope, and have it in his file. That made me a little nervous. I appreciated the practicality. It's on the one hand a wonderful idea. On the other hand, potentially problematic. Someone could find that. Also, I expect that his passwords are going to change over time because we're all being forced to do that. But one of the topics that we mentioned is cryptocurrency and Bitcoin, and there's really, I'm not a banking person. I only have a sort of a loose understanding of this. But what people will throw around is the KYC process, which is the know your customer process. The SWIFT banking network has been in the news because of the war and potential sanctions. It's something that arises. It's a big part of that network, and it exists so that financial institutions can know their customer, know that they're not involved in criminal activity. And the same is true with crypto. If you own Bitcoin, it's probably going to be through something like Coinbase or Robinhood. And those companies have very strict rules about access. And I've run into numerous occasions with clients where, Coinbase or Robinhood is not letting them do anything. They're not letting them use an online tool. They're not letting them execute some kind of a beneficiary designation. And as far as those issues, it's kind of a work in progress, that I'm trying to help the clients work through. But to go back to my client who put everything in an envelope, the solution so far has really been as elementary as making sure somebody knows your login and your password, so that you're not totally shut out, because there's this tangible and intangible aspect to the digital asset universe. I mean, photos, super important, sentimental, intangible, but then these incredibly valuable tangible assets, it's still an evolving process as far as how we can access those. So sometimes the practical solution is the best one.
Yep. And I agree. We recommend really a 4-step process for people to manage them, starting with keeping an active list of your online or your digital assets or your digital presence. Keep a list as problematic as it can be, a secure list of your login, your usernames and passwords, we recommend using some kind of password tool, secure password tool that's got a master password. And then deciding what you want to have done with each of those things, and how you want them handled. If it's something you simply want shut down and turned off, then make a note and make sure on your list that you've got your instructions in place. And then decide who is going to have access to this, who are you going to assign as your digital fiduciary. And maybe ultimately, I was thinking about this when we were starting off today, maybe you talked about the financial power of attorney and the healthcare. Maybe at some point we'll have a digital power of attorney that becomes another essential document and part of all of our estate plans. But who's going to help with that? Who's going to take care of it? I think is important. And then making sure that you've got you kind of make it legal, or you incorporate it in with the rest of your estate plan, that it's recognized in your financial documents. We got a question that's come up here that says, it just says thank you. So thanks everybody. We are running close to the end of our time. So if anybody has any final questions, let us know. Happy to address them. And as we start to wrap up, maybe Andy, where do you see this going? This kind of digital presence and kind of the evolution of how we need to think about enhancing estate plans. What do you see on the horizon?
Well, I think that the big thing was, do we have something to get around these terms of service, right? And I think we've gotten past that. We have a law. People are putting directions in their estate plan, but it feels to me like kind of a first crack, right? The online tool piece, I think, is going to be very important. I would hope that more and more companies are going, like Apple, are going to recognize that this is a problem, not simply say, privacy, terms of service, we're not going to deal with this because it's easier for us. We're not going to get sued, so we're just going to say we're not going to deal with it. Because, as you pointed out, most of the time we're talking about access to these digital assets. It's also the case that you might not want your asset accessed. And these online tools provide either access or the ability to provide a limitation. I do think that we're going to be developing and seeing more specific documents and more specific designations in the estate planning world. I mean, one thing that I've been thinking about is we've got the statute. It says if there isn't an online tool, then is there a direction in the estate plan? That's all good. We're putting a direction in the estate plans. But a big part of what we do is try to avoid probate.
Right.
Right now, we might have a direction in the estate plan, but that asset is probably a probate asset. So if we are relying on the direction that we've nicely put in the estate plan, it's probably all happening at the probate level. And when you have an estate plan in place that's designed to avoid probate, maybe there'll be a better way. I mean, I know with something like LLC interests, we might execute an assignment of interest to your trust. One thing that I've been thinking about is, should we be having clients execute assignments of their digital assets to be governed by their trust, and have some nice language in the trust? I'm hoping as things evolve that, that might be something that's accepted, or a technique we can use to streamline things.
Well, preview of coming attractions. So we don't have all the answers today, but I want to thank you, Andy, for joining me today and in a robust conversation about estate planning in Vermont and how we should think about digital assets and the rapidly evolving area of kind of thinking about digital estate planning. So thank you, Andy, for joining me today. Thank you, everyone who joined today. Join me next month. We're going to be talking about giving circles next month, and another kind of developing and growing area around in the world of philanthropy. Thanks, everyone. Have a fabulous rest of your week, and see you next month.